This was a new philosophy for the court. Why would the court take Jefferson's letter completely out of context and cite only 8 of its words? Dr. William James, the father of modern psychology and a strong opponent of religious principles in government and education, perhaps explained the court's new strategy when he stated, "There is nothing so absurd, but if you repeat it often enough, people will believe it." This statement precisely describes the tact utilized by the court in the years following its 1947 announcement. The court began regularly to speak of a separation of church and state, broadly explaining that this is what the founders wanted, separation of church and state. This is their great intent. The court failed to quote the founders. It just generically asserted that this is what the founders wanted. The courts continued on this track so steadily that in 1958, in a case called Bear versus Colmorgan, one of the judges was tired of hearing the phrase, and he wrote a dissent warning that if this court did not stop talking about separation of church and state, people were going to start thinking it was part of the Constitution. That warning was in 1958. Nevertheless, the court continued to talk about separation until June the 25th, 1962, when in the case Engel versus Vitale, the court delivered its first ever ruling which completely separated Christian principles from education. The court struck down school prayer. Even the World Book Encyclopedia 1963 yearbook noted that this case was the first time that there had been a separation of church and state in education. In the 1962 case, the court redefined the meaning and application of a single word, the word church. For 170 years prior to that case, the word church, as used in the phrase separation from church and state, was defined to mean a federally established denomination. However, in 1962, the court explained that the word church would now mean a religious activity in public. This was the turning point in the interpretation of the First Amendment. Understand what the court has just announced. No longer would the First Amendment simply prohibit the establishment of a federal denomination. It would now prohibit religious activities in public settings. This current doctrine of separation is a brand new doctrine. It is not something from the Founding Fathers, and it is not in any founding document. Even outside observers recognize that this policy is a recent one. Yet notice how much has been relinquished in recent years under this new doctrine. School prayer was the first casualty of the redefinition of the First Amendment in the 1962 Engel case. School prayer had never before been challenged, for clearly school prayer had never established a national denomination and therefore had always been acceptable. But school prayer definitely was a religious activity in public and was therefore now deemed to be unconstitutional. That 1962 case, which first redefined the First Amendment and then removed school prayer, was notable in a number of aspects. Recall that the 1892 Supreme Court case offered 87 precedents to maintain the inclusion of Christian principles in our laws and our institutions. Well, this 1962 case, which removed school prayer, was just the opposite. It was the first case in court history to use 0 precedents. The court quoted 0 previous legal cases, and without any historical or legal base, the court simply made an announcement. We'll not have prayers in school anymore. That violates the Constitution. A brand new direction was taken in America. Within a 12-month period of time, in 2 more cases in 1963, the court had not only removed prayer, but also Bible reading, religious classes, and religious instruction. This was a radical reversal. A book from 1946 illustrates this. This book is titled Bible Study Course of the New Testament for Dallas High Schools. On the cover page, it explains that this book was authorized by the Board of Education on April 23, 1946, and it was printed in the Dallas Public Schools print shop. The introduction further explains that this was a credit course toward graduation in Dallas high schools. Now, this wasn't a bland course on the New Testament. Lesson 1 begins with the Gospel of John, chapter 1, and studies the pre-existence of Christ. Now, notice the questions based on John chapter 1. Where was Christ before he was born on earth? What titles does John apply to Christ in this chapter? For what purpose was John sent by God? Name 5 things the angel told Mary concerning her child Jesus. What does the word Jesus mean? How did the angel explain the miraculous births of John and Jesus? And continues right on through the lesson. At the end of lesson 1 is memory work. Memorize the pre-existence of Christ. In the beginning was the Word, and the Word was with God, and the Word was God. All things were made by Him, and without Him was not anything made that was made. This was a textbook for public schools in 1946. What had occurred in the 1962 and 63 rulings was a radical reversal of national policy prior to that point. It was in the Abingdon v. Shemp and Murray v. Curlett decisions on June the 17th, 1963, that the court not only reaffirmed its ban on school prayer from the previous year, but further reached out and banned school Bible reading. Recall that in the brief survey already presented, the founders relied on the Bible, early textbooks quoted the Bible and used it as part of the alphabet, and earlier Supreme Court cases ruled that a school must teach religion and the Bible. Therefore, on what possible basis can the 1963 court justify its ruling to stop the use of the Bible in schools? The court always explains its decision in written form. That 1963 case was no different. If you go to a law library and examine the text of that decision, you will find why the Bible had to be removed from school. In its written decision, the court noted that, quote, if portions of the New Testament were read without explanation, they could be and had been psychologically harmful to the child. Now that's quite a statement. For the second time in a year, this was a case lacking both historical and legal precedent. Again, the court simply made a new announcement of policy: no more Bible reading in schools. The courts continued to extend the new boundary outward. In 1965, in the case Reed v. Van Hoven, the court determined that it was possible for students to pray over their lunch at school so long as no one knew they were praying. They couldn't say words or move their lips, but they could pray if no one knew about it. In 1967, in DeKalb v. Despain, the court took a 4-line nursery rhyme used by a K-5 kindergarten class and declared that nursery rhyme unconstitutional. The court explained that although the word God was not contained in this nursery rhyme, if someone were to hear the rhyme, they might think that it was talking about God, and that would be unconstitutional. This trend continued in case after case, year after year. In 1 year alone, 3 cases made the courts challenging the right of students to see copies of the Ten Commandments while at school. The Supreme Court accepted the Stone v. Graham case from Kentucky, where a copy of the Ten Commandments was hanging in the hallways of the schools. The court acknowledged that the Ten Commandments were passive displays. That is, they simply hung on the walls just like a picture of George Washington. They were not part of any class or any curriculum. They just hung there. A student could look at them if he wanted to, and if he didn't, fine. Yet notice the court's ruling under the redefined First Amendment. The court said, if the posted copies of the Ten Commandments are to have any effect at all, it will be to induce the school children to read, meditate upon, perhaps to venerate and obey the commandments. This is not a permissible objective. That's quite a statement. You can't let kids see the Ten Commandments, because if they do, they might obey them. Things like don't steal, don't kill, and that would be unconstitutional. When the court declares something unconstitutional, it is inferring that our founding fathers, the men who drafted the Constitution, would have opposed it. Yet notice what James Wilson had to say about this. James Wilson was a signer of the Constitution, an original justice on the U.S. Supreme Court, and co-author of America's first commentaries on the Constitution. Certainly he's qualified to speak to the intent of the Constitution, and he explained, human law must rest its authority ultimately upon the authority of that law which is divine. Far from being rivals or enemies, religion and law are twin sisters. Indeed, these two sciences run into each other. The divine law forms an essential part of both. Our founders were clear about the important and inseparable role that religious principles played in the public life of the nation. The entire controversy over God and religious activities and teachings in school had begun with the 22-word prayer in the Ingle Vitale case. That 22-word prayer, the prayer that led to the removal of all prayers from America's schools, simply said, Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. That prayer, which only acknowledged God and didn't even contain the word Jesus, was a bland prayer. It was so bland that 8 years later, when a court was discussing that prayer, it described that prayer as a, quote, to whom it may concern prayer. That bland prayer acknowledged God only once. That one acknowledgement of God is the same number of times that God is acknowledged in the Pledge of Allegiance, and only 1/4 the number of times that God is acknowledged in the Declaration of Independence.
Welcome back to Truth Seekers. What do you guys think out there? Phone numbers will be up on the screen, and you can call up. And I know we've had a number of calls during the lengthy sections that we showed, and I don't know if anybody's holding, I guess not at the moment. But I would expect some of you to be a little shocked by what you just heard and saw. I mean, everything has been reversed.
Completely reversed. The Supreme Court, Mike, used to use the precedences to make a decision in a Supreme Court ruling, and now they don't even do that anymore, Mike. As long as it pertains to Christianity, well, we're not even going to go back to the founding, to the original Supreme Court rulings and findings. We'll just make something up brand new. I find that quite interesting, into the embracing of, in this, but yet at the same time they preach diversity. But